Our final panel this afternoon, I will first introduce the moderator, who will then introduce our panelists from left to right. But before he does that, he's also going to give a little bit of context for the exciting space law panel as well. So to my left here, this is Dr. Hernandez. He holds both an undergraduate and graduate degree in electrical engineering. He has been a successful scientist and engineer at the Lawrence Livermore National Laboratory, and Dr. Hernandez became the first migrant farm worker to become a NASA astronaut, realizing his ambition of reaching the stars in a space mission to the International Space Station. We are also very privileged to have Dr. Hernandez as a member of the University of the Pacific Board of Regents, so I hope you will all welcome him here with me. Thank you.
Thank you, Rachel, for those kind words. Welcome to the panel, The Next Frontier, Space and Beyond. I think the first thing before I introduce the panelists is I'd just like to give a few remarks about myself, about what motivated me to become an astronaut and how I went about it. It'll be very quickly, but if you could imagine a 10-year-old boy in 1972 watching live the very last Apollo manned mission to the moon. Still remember the name of the astronaut who was walking on the surface of the moon, and you could imagine a 10-year-old boy holding a rabbit ear antenna, watching Gene Cernan walk on the moon, hearing him talk to Mission Control Houston, hearing Walter Cronkite narrate those images. And man, I was hooked. I knew at 10 years old I was going to be an astronaut. And the best thing I could have done that day was share that dream with my parents, who at the time were migrant farm workers. My dad had the smartness to take my desire seriously. Sat me down on the kitchen table, same kitchen table where my mom sat us down every day to do our homework, and gave me a simple 5-ingredient recipe. He says, "You want to be an astronaut? Follow these 5 simple rules, and you'll get there." He said, first, decide what you want to be in life. Second, recognize how far you are from there. Third, draw yourself a roadmap that will serve as a guide throughout your life to get you there. Fourth, get yourself an education. No substitute for an education. Fifth and final, he says, the same effort you put out there during the weekends and 7 days during the summer, picking cucumbers, cherries, tomatoes around Stockton, he says, you put that in your books, pointing to my books. And then when you graduate college, he said, you put it in your job. He said, always deliver more than what people expect of you. He said, you mix all that up, he says, that's the recipe to succeed. And I think the only other ingredient I would add would be perseverance, because NASA didn't accept me the first time. They rejected me not once, not twice, but a record 11 times. And it wasn't until the 12th try, so there's something to say about perseverance. So those of you students that are looking to taking your bar, it don't have to be the first time, all right? Let's remember that. We want it to be the first time. Don't get us wrong, but it's not the end of the world if it's not. Okay. So having said that, I digress a bit. Having said that, we're here to talk about space and beyond, and I just want to give a few thoughts with respect to what our panelists hopefully will be talking about. But obviously, I was telling Rachel that the last thing I thought about when I was in space was about lawyers. Yet here we are. But that's okay. That's okay. But you really want to think about that, because if you look at it, for example, the International Space Station is an effort that was put together by 16 nations to put together that, and so there's a lot of issues that have to be ironed out in terms of saying, okay, who has the right to what and what can they do and all these kind of things that you have to do. And then, you had a space treaty signed in 1967 with the UN, and not all countries signed, but most of them signed, and so that guarantees that space can't be claimed by a particular country. But then the ones that aren't participating, are able to put up things up in space, maybe use kinetic energy type of weapons to destroy their own satellites and create all this space debris that causes us havoc. Then you got all these other outfit companies that, you know, will sell you anything from outer space, including a plot of land on the moon. I mean, can they do that? I don't know. But yet they are, and it's a big thriving business. So you know, this international space law that we're about to hear about, I think it's something that's very important, that's going to become even more important as companies are private companies are developing the capability to go up into space, and what is it that they can do once they're up there. And I think our panelists are here to talk about that. And having said that, I think I'd like to introduce first the panelists, and then I'll allow them to go ahead and talk a little about what their thoughts are. But if you help me welcome the first panelist is Judge Fausto Pocar, International Criminal Tribunal for the former Yugoslavia. Fausto Pocar is Professor Emeritus of International Law and former Dean and Vice Rector of Milan University. As of 2000, an appeals judge at ICTY and ICTR, as well as the ICTY president from 2005-2008. He has a long-standing experience in UN activities, both in the field of human rights and humanitarian law. Next, I'd like you to introduce Leslie Tennen from the law firm of Stearns and Tennen. Leslie has focused on space law matters for more than 35 years. Mr. Tennen was awarded the highest score on the February 1977 Arizona bar exam, and he wasn't awarded, he earned it. You're not awarded that, you earned that, sir. And is a partner in Stearns and Tennen, the first law firm to be elected to membership in the International Aeronautical Federation. He served 2 gubernatorial appointments as commissioner on the Arizona Space Commission. And our third guest is Mr. Wayne White, president and CEO of SpaceBooster LLC. Wayne White is president and CEO of SpaceBooster LLC, a small business with offices in Albuquerque, New Mexico. Mr. White graduated from Chapman University in Orange, California, received a master's degree in business administration from UC Riverside, and received his law degree from UC Davis. He has a certificate. He has a certificate in government contracts management from UCLA and a certificate in entrepreneur development and management from the Technology Ventures Corporations. So I'd like to welcome all, these 3 panelists, and I think what we'll do is we'll go ahead and allow each one to speak a little bit about the implication of international law and property for the development of outer space law. And if we could go ahead and begin with Judge Pocar, appreciate it.
Thank you for the presentation. Let me first thank Rachel Salcido for inviting me to this event. It's always a pleasure to come to McGeorge and talk every time on a different subject. Because that's the case that occurs. But it's the first time I speak about outer space. And perhaps you have heard a CV basically on human rights. I would say, what has human rights to do with outer space? But it happened to me once to talk of human rights and outer space, and because they wanted me to speak of the 2 topics of my experience, because I was a member for years of the Committee on the Peaceful Uses of Outer Space, and the only thing I could find was right to privacy, talking of remote sensing, which indeed may impact on right to privacy. Let me begin by recalling that the question of sovereignty, property over our space and celestial bodies has attracted attention many times in the past, even before that exploration of space started, where just writers invented questions, or people that simply claimed to have to sell parts of space, parts of the moon, and but actually the law of outer space starts only after the first satellite was sent into an orbit by the Soviet Union in 1957. And as of then, incredibly, the way the law of outer space has become a daily work for the world. In only 5 years, a declaration on principles governing the activity of states in outer space was adopted by the United Nations, and immediately afterwards, a few years later, we have the famous Treaty on Outer Space, which includes, is more or less the same as the resolution. The text is the same of the declaration, with an indication in the title there is also the moon, because in between the man had almost arrived to the moon. So it became an important issue. Now this treaty, just to set the framework, the legal framework, this treaty is a treaty that has evolved, in fact, into customary law. A treaty that has become jurisprudence. Not all the states have ratified the treaty. Around 110 states have ratified the treaty, plus a number of signatories that have not ratified yet. But de facto, the treaty has been followed always as being the law, the basic for the law. And we have to look at this, if you look at this under the angle of jurisprudence, clearly any activity, any problem, any issue, including property, has to, and its limits, has to be checked against a rule that cannot be changed, except by another rule of jurisprudence, another rule that would be customary under jurisprudence. But certainly another treaty may not change the rule as it is. Now, what is this treaty essentially establishing? First, and I go only to the basic principles. The two basic principles is the freedom of the outer space. Article 1 sets this principle as a basic principle. And the second is that outer space, including celestial bodies, including the moon, other planets, is not subject to national appropriation, by claims, I quote, of sovereignty by means of use or occupation or by any other means. So the principle is freedom of states in outer space, but at the same time, no possibility of appropriation of any part of the space, be it orbits or be it land in the sense of celestial bodies. And these principles are clearly accepted. So we have to do count of these are mandatory principles that have to be observed in any time. If we read the principle on appropriation as it is in the treaty, it excludes appropriation, we said, by occupation, which is a traditional form of acquiring sovereignty and property, and by use. Under Article 1, the use of the state is free. Article 1 speaks of free use of state. But at the same time, that use cannot lead to appropriation. So the limit of use will be, to a certain extent, non-use of the state, because using it too much, if you take something, if you take a stone, you clearly become owner, or take the stone for yourself, you appropriate yourself of the stone. So if taken very rigidly, the treaty is really a treaty that stops any activity in the states, almost any activity in the states, except the mere exploration and scientific research. Scientific research in various articles is accepted. Now, this applies both to states and to private enterprises. It's not just states. States are bound by these principles, but private persons as well. The drafting history of the provision clearly explains that when saying by other means, the other means implies also non-appropriation of the outer space through national or other, and that's been accepted by legal doctrine as of the beginning, especially the drafters of the treaty, that this non-appropriation includes sovereign rights of states and private property rights. The creation of any title of property right should be excluded as to any celestial body. This situation legal situation is reinforced by a subsequent treaty, the Treaty on the Moon. The Treaty on the Moon that was adopted many years later in 79, but not so many. In 79 there was already the Treaty on the Moon, makes clear explicitly that neither the surface nor the subsurface of the moon nor any part thereof or natural resources in place shall become property of any state, organization, non-governmental entity, or of any natural person. So the treaties speak clearly of property right. Is property that is excluded for what we have to discuss in this panel. It's true that the Treaty on the Moon has little weight because it's more or less a failed treaty in the sense that it's been ratified by a handful of states, I think 16 at the moment, very few, there are a few signatories, and there is no prospect probably that it be ratified by others. But still, it is an indication that that the appropriation of celestial body is not possible unless one reads the other way around, and the fact that it's not being ratified when it was so specific means that in reality the principle of non-appropriation is not so well established. The states are not happy to accept it fully. Now, for what is of our colloquium today, should we say that we close the subject? There is no property right. We are discussing property. Should we say that property rights are not possible in outer space, except, of course, for what is property over objects launched by states in outer space, because on these states retain clearly their sovereignty. Should we conclude that the treaty wanted to have a sort of socialist approach to property in outer space, and that there is no right to property at all? Who owns the moon celestial body would be mankind. So a community, the whole community, or the totality of the states. Or we should consider that perhaps the treaty does not allow property rights simply because one of the main actors in reaching the treaty would not have allowed ever a treaty that would confer property rights to enterprises, to private individuals. Certainly, this treaty is an agreement basically between the United States and the Soviet Union, and were the only states that had some capability to reach outer space. And clearly the Soviet Union would not have accepted to adopt a rule that conferred property rights. So is that a possibility of interpreting now the treaty in a different way once the problem of private property is no more a problem for one of the actors? I think that interpreting the law, this treaty, one has to take into account not just as normally we do with the Vienna Convention, the words, but the context in which the treaty was adopted. The treaty was adopted during the Cold War. And the main goal of the main state that adopted the treaty was not to prejudge anything in outer space, but at the same time to ban any activity that could become a factor to increase the difficulties of the Cold War. It's not by chance that the legislation on space was not conferred to, as it should have been obvious, to the committee in the United Nations that deals with international law, the committee where Steve was a member for some time. Was the codification of space law was taken up, was not left to experts. Experts are too dangerous. So was brought to not even to the Committee on Armaments, because that would have been, we were just discussing the militarization of space. Was brought to the committee that does not exist anymore. It was this so-called Special Political Committee, where issues of certain importance, certain difficulty for states were put, and where, of course, the expert committee reported, the COPUOS, the Committee on Outer Space, reported, but reported to a group of delegates that was particularly careful of what could be adopted and what could not be adopted. Now, in light of, we have to take that into account in interpreting the treaty, that the main goal was to keep space out of the Cold War, that essentially, not just to regulate in detail what could be done. And the best way to keep it out was to say, you can't do anything, it remains out. So there is no activity, no property possible there. Otherwise, the ownership of celestial body could have been a matter for wars between the main powers. Now, in light of this situation, can now a state confer property rights? This is the main issue. And it's the main issue also in light of an initiative that has been taken in the United States recently in Congress. Two members of the Congress last July submitted a bill to allow the administration to confer property rights to companies, to enterprises. It's a bill transversal. One of the two is a Republican, the other one is a Democrat. So it clearly means that behind there is a lobby of companies that are interested in this exploitation of our space. Can we, I don't know what will be the issue of this initiative, of this legislative initiative, but we can expect there will be more, and maybe in other states, not necessarily only in the United States. This is a first. But can we imagine that a law of this kind may be compatible with the stringent principle the outer treaties. Well, the treaty is clear in banning property, but it's perhaps too clear. It's too rigid. It says it's too loud to be true. Because if one reads in between the lines of the treaty, there are some problems of interpretation. I mentioned there is use of outer space is free. Appropriation by use is not. But what does mean use? What is use? How far one can use the space? Can use the resources in the space? Can, for instance, use metals, minerals to build something, to build a machine, and then the minerals remain in the machine, of course. Is that possible? Use implies exploitation or not? What is essentially use? Well, in the travaux préparatoires, the question remained a bit open. There was some discussion between delegation that was kept on a very soft level and probably went not in depth simply because the idea was that it was too early. It was premature to adopt any regulation and to discuss a regulation because nobody thought at the time that it was possible to really exploit outer space. Now, I know my time is over. I have not finished, but I can come back after my colleagues have taken the floor and perhaps say later where we move on, in my view, on this matter. Thank you for the attention.
Thank you, Judge Fausto. And next to talk about the same subject is Leslie Tennen. Leslie?
Need a little help with the PowerPoint?
Do you have a USB?
No, it was on.
Oh, right here. Here it is.
Yeah.
Excuse me. Good afternoon. It's a pleasure to be here. I'd like to thank Professor C.E.O. for the invitation and commend Professor Sprankling for his excellent book. I've had the opportunity to read the chapter on outer space, and he has done a remarkable job of encapsulating many of the current issues and explaining them extremely well. I'm going to be speaking today on the utilization of extraterrestrial resources as the primary focus of the property rights as such that I'm going to be discussing here. And I take the view, as do many of my colleagues, that space is unique and that the analogs in traditional law, particularly in air law, maritime law, and in Antarctica, can be instructive, can be informative, can be very useful, but ultimately they are somewhat incomplete. Space is a unique environment, and as such it will require a unique approach that's not burdened with the historical shackles of Terran-based legal regimes. It needs to be able to protect the interests of all parties concerned with the use and exploration of space. And it will develop its own rules and regulations and its own frame of reference as things move along. Of course, drawing from the other analogs in international law. The fundamental parameters of the regime have already been established, as Judge Pocar has already indicated, primarily through the Outer Space Treaty. And additional components are provided by domestic law, and that's one of the areas where I hope to put some of my focus today. Ultimately, of course, the law strives to provide predictability, transparency, and enforceability. All of those are necessary for us to move forward with utilization of extraterrestrial resources. The primary legal instrument, of course, is the Outer Space Treaty of 1967, which followed along from prior United Nations resolutions going back to 1961. There were a series of them. But United Nations resolutions do not have the force of law, so it was quickly recognized that a more formal document would be necessary, and the Outer Space Treaty was the result. It entered into force in 1967. We're coming up on the 50th anniversary, and at this point, more than 125 nations have ratified or have signed it. And of course, the keystone here is Article 2 of the Outer Space Treaty. Outer space, including the moon and other celestial bodies, is not subject to national appropriation by claim of sovereignty, by means of use or occupation, or by any other means. As the judge has pointed out, extremely sweeping language. I'm not sure that we need to look at limitations on that language. I think as a general principle, it remains as viable and as important as when it was first articulated in the early 1960s and then put into the Outer Space Treaty. The substance of Article 2 was reaffirmed in Article 11.2 of the Moon Agreement, but the Moon Agreement, as the judge has pointed out, utilized different language, much more specific language. In my view, there is not a substantive difference between the Moon Agreement and Article 2 of the Outer Space Treaty. The Moon Agreement simply expresses it in more detail, but the essential elements are contained within Article 2 of the Outer Space Treaty. The non-appropriation doctrine has received widespread acceptance and represents state practice for more than 50 years, and indeed as one of the primary provisions of the Outer Space Treaty, which may well have become customary international law. And if so, it would be binding on all states, whether or not they are party to the Outer Space Treaty or the Moon Agreement. Now, the first question that lawyers have is definitional. What do we mean by celestial bodies? We know what outer space is, but and we know what the moon is, at least the moon that orbits our planet. But what are celestial bodies? They are not defined in the treaties. The International Astronomical Union adopted definitions in 2006 when poor Pluto was demoted from planetary status. I got in a lot of trouble for saying it was a demotion, but that seems to be the prevailing view, at least of the people that didn't attend the IAU meeting that year in Prague. But it's clear that the celestial bodies include the sun, planets, including the Earth, although the Outer Space Treaty does not limit the utilization of Earth resources in the same way it does outer space resources. The moon and other moons, and the moons of other planets, near-Earth objects, dwarf planets, Ceres and Pluto, trans-Neptunian objects, whatever those are, and asteroids, comets, and Kuiper Belt objects. And if you define celestial bodies to exclude any of these objects, then that opens up a whole area where perhaps the entire basis of space law no longer has any applicability. There is a lack of consensus as to what resource utilization will entail. There's the assertion of traditional forms of property rights importing from Terran systems, or on the other hand, there are those that say that it is completely beyond the grasp of the private sector. I don't believe that either of those are particularly accurate. The fundamental elements are articulated in the treaties and other international agreements and are supplemented by domestic laws and licensing regimes. In my PowerPoint, I've got some references to some of the other authors. I won't go into their particular works, and a couple of times I've cited my long-standing, I won't call him my old friend, but my long-standing friend, Wayne here, will speak for himself on those. The point I'd like to make here is that the utilization of the phrase or the term property rights, in my mind, is somewhat confusing and misleading. What we're really talking about is enterprise rights, at least in the sense of what private entities can do with extraterrestrial resources. How can they utilize the resources within the bounds of the law and not violate the non-appropriation doctrine? no single model of regulation will be appropriate or effective for all locations and in all circumstances. And so the rules that are developed for the moon may not be appropriate for near-Earth objects or asteroids, and they certainly may not be viable or appropriate for Mars or other areas where we may ultimately establish a human presence. If I can go back to this, much will depend on the particular circumstances of the resources, the intended use, the relative abundance or scarcity of the resource and the location. I'd like to discuss a little bit about the history and how we got to be where we are with Article 2, to put it all in the proper context. To elaborate a little bit on what the judge had said. And I do want to point out that Professor Sprankling has raised an excellent point in his chapter that all too often has been overlooked in the literature. And that is, during the Cold War, the two antagonists, looking for some kind of common agreement here, when it came to the non-appropriation provision, that fit in very, very well with the Soviet philosophy. So they were quite willing to outlaw private claims in space. For the Western world, the United States and the Western countries, they were faced with a real dilemma. They could either adopt the non-appropriation principle, or they could recognize that the Soviet Union, through historical means of physical presence, planting their flag, other rituals, had prior superior claims to lay over Earth orbit, the moon, and other areas of space and celestial bodies. After all, the Soviets were the first to orbit the Earth. Why couldn't they then claim low Earth orbit as Soviet territory? Similarly, as early as 1959, they impacted on the surface of the moon, established a physical presence on the moon. Then if there was not the non-appropriation principle, why couldn't the Soviets claim ownership of the moon? The way around that was the non-appropriation principle to be adopted, and in doing so, that served the global community in a very real and tangible way by eliminating or at least substantially reducing the environment of outer space as a realm for armed conflict and for military conquest. Eileen Galloway, one of the founders of American space law, said that this was a tangible benefit of space law, which all too often is overlooked. The cost of conducting missions would increase in direct proportion to the defensive planning, armaments, and weaponry necessary for protection and personnel in spacecraft if we were not able to outlaw the militarization of space. Now, of course, that doesn't mean that all military uses of space are outlawed, but it does mean, and the Outer Space Treaty does provide, that military maneuvers, military installations are prohibited in space. In my view, the law of outer space advances and enhances commercial opportunities for the private sector through the non-appropriation principle. It establishes the basic parameters of the legal regulatory regime applicable to private entities, but it also prevents the competition from claiming and obtaining a monopoly over certain resources. One of the most important coming up right now is the discovery of water ice deposits on the south pole of the moon, and quite possibly in other locations in some of the craters, maybe on the far side in some other areas. The Outer Space Treaty makes it clear that activities in space must be conducted in conformity with international law, not just the space law treaties themselves, but international law in general, and including a specific reference to the Charter of the United Nations. Now, we come to the question, does Article 2 apply to private entities? It doesn't mention private entities in its terms. That is conceded, that much is clear. However, the Outer Space Treaty provides that states are responsible for national activities conducted in space under Article 4, and national activities are described as activities whether conducted by governmental or non-governmental entities. That means private entities. And the appropriation by private entities is dependent upon state sanction, and state sanction would violate Article 2. That position was adopted by the International Institute of Space Law Board of Directors in 2009, I believe, was the first statement, and then it was reiterated a few years later. And the Outer Space Treaty requires that private entities are to be supervised and operate under the authority of the state. They must be essentially licensed in the domestic law regimes, at least within the United States. We have a whole series of regulations on how private entities can obtain a license to conduct activities in states, although there's a lot of gaps in there and a lot of questions about it and its extent, the breadth of it. But it is clear that private entities need to be licensed or authorized and supervised by their state. The state cannot authorize private entities to violate international law. That is, a state can't license a private company to go into space and conduct activities that the state itself is prohibited from conducting. You can't get around the Outer Space Treaty by allowing a private entity, by just saying that a private entity can go and do that. The non-governmental entities are subject to the continuing supervision by the state. And so it would cover not just their original activities, but their ongoing activities as well. Within the United States, the licensing regime does have a lot of gaps. Right now, it essentially covers launches into space and the return of an item, of an object from space, but doesn't really go into detail or depth about activities while you're in space. Other countries have adopted licensing regimes that are somewhat similar. There are a lot of similarities within the basic licensing provisions, and about 15 different countries so far have adopted licensing regimes under their domestic law. The space treaties don't require any particular form of licensing regime, and so states can adopt any form that they deem appropriate, consistent with their national interests and policies, subject to their international treaty obligations. Primarily, the licensing regimes deal with liability and insurance concerns. And the reason for that is because under the Outer Space Treaty, launching states, and we can talk about that definition, but if you'll just bear with me, states that launch objects into outer space are internationally liable for damages caused by those objects to other space objects on the basis of fault, or damages caused on the surface of the Earth or to aircraft in flight. And that is an absolute strict liability regime. Because the launching state has liability even for the activities of the private entities that they license, the state wants to make sure that its backside is covered. And so they do that primarily through the requirement of insurance, and there are varying limits depending on which country. In the United States, the Office of Commercial Space, through the FAA, determines what they consider to be the maximum probable loss for an activity and then determines its insurance. About that, there are statutory limits within the U.S. Code. There is a question whether or not those limits are applicable to the state, because there are no limits in the treaties themselves. If I might add, there are a couple of other areas where domestic laws have been extended into space: intellectual property, which we heard about a little while ago, and chain of command of personnel is another area. Now, there have been all sorts of proposals and to allow for private claims of ownership of space resources. Generally, they are dealing with claims to areas of the surface of the moon or other celestial bodies. And as those proposals are made, I would ask that you keep in mind how they can work without state sanction of a claim of appropriation. That is the Achilles heel of most of them. They ultimately come down to the state having to enforce a claim of private, quote unquote, private appropriation, which is a direct violation of the non-appropriation provision of Article 2. So there have been all sorts of proposals where they play around with words and semantics and try to proclaim that they will allow registration of claims and so on, but that it is not appropriation and it's not in violation of the Outer Space Treaty or the non-appropriation provision, but these are really distinctions without a difference. And as I mentioned before, the recognition of claims is only one side of the equation. The other side is the exclusion or rejection of any competing or conflicting claims. The de facto exclusion by its very nature would constitute a form of national appropriation, and the language by any other means is broad enough to cover those, no matter what euphemistic label may be employed to mask the obvious attempts to appropriate by private entities. So now the next issue for lawyers is, well, if the non-appropriation principle prohibits us from doing something, maybe we should get rid of the non-appropriation principle. Okay? From a legal perspective, that is a valid area of inquiry. However, the abrogation of the non-appropriation principle wouldn't help private enterprise. They would permit claims of national sovereignty by the technologically advanced nations, the United States and Russia as the successor to the Soviet Union. The claims would include various orbits, the moon, or other areas where the claimant has any basis for asserting that it was the first to discover, whether that be by exploration, use, landing, imaging, telepresence, mapping, surveying. And the Russians would have the historic justification for claiming vast reaches of near-Earth space. If that state of affairs comes to pass, American private enterprise is going to be at a severe disadvantage. And other nations, of course, can be expected to lay claims to space properties, which would lead to conflicting and overlapping claims that ultimately would depend on military means in order to enforce them. Now, because time is very short and there is a fair amount of overlap, I want to get, if I can, to some of the domestic law aspects here. I may not be able to find it quickly, but before I get into that, regarding the Moon Agreement, the big problem with the Moon Agreement isn't its elaboration of Article 2, but further in Article 11 of that document, it discusses that the moon and its resources are the common heritage of mankind. And that is the phrase, that is the area that has caused so much trouble. That is why the United States is not a signatory to the Moon Agreement, and most of the other countries have not joined it either. However, and this is an important point that I wish to make here, is that the Moon Agreement cannot be overlooked or disregarded, even though the United States hasn't signed it, and even though Russia hasn't signed it, and even though the 15 to now approximately 20 countries that have signed or ratified it, and there are new ones coming every couple of years, it is still gathering some adherents. Up until a year ago, it was said that the Moon Agreement has no validity because none of the countries that are parties to it have any independent space capabilities. Up to a year ago, that was indeed true. A year ago, that ceased to be true when India launched and orbited a craft around Mars. Under the Moon Agreement, its terms apply to other bodies within the solar system, which would include Mars, unless and until specific agreements are adopted regarding those particular bodies. So now we have state practice by a country that is a party to the Moon Agreement that is involved with a celestial body. That gives new impetus, new viability to the Moon Agreement. Also, I'd like to state that, before my time completely runs out here, that the utilization of natural resources, once they are extracted, does not appear to be a violation of the non-appropriation provision. Of course, everything must be looked at in context. So if somebody was to go to the south pole of the moon and start to mine the ice and utilize the oxygen and hydrogen that would be derived from that, they may not be able to claim a monopoly on for that area, and they may not be able to prevent other states from establishing similar facilities, similar operations in proximity. There are, however, and I want to mention this very quickly, provisions within the Outer Space Treaty regarding interference with the activities of other countries, and there are procedures for consultations depending on who's involved with it, so that if there is somebody that is in one area in another country or another entity wants to utilize that same area, there needs to be some consultation, some coordination. If that is not done and there are damages or interference, then there are liability aspects in the Outer Space Treaty and the Liability Treaty that could come into play. Now, the one thing that I do want to state about the domestic laws is that, in my view, the domestic licensing regimes provide a tremendous opportunity for clarification in this area. In order for a private citizen to conduct an activity in space, say an American, they need to apply for a launch license, assuming that they get it, and they go to the moon, conduct whatever mining operation, whatever resource extraction and utilization they want to do. Then the question is, what are the limits to that, and what other entities, what other activities can other entities conduct? And this is where the reliance on property rights falls, in my view, because it's not necessary to claim ownership. There's all sorts of different areas where ownership is not needed, and you can still utilize resources. But more than that, the licensing regime protects the entities that are there, because if an American company gets a license to go to the moon and mine, then the United States government is probably not going to go into direct competition with them, nor are they likely to license another American company to operate in the same area. They can operate in proximity, but they will not be granted a license which on its face is going to cause interference with somebody that already has a license. If that was to happen, then the first license holder would have recourse through the American court system. They could put a challenge, objection, and so on, and try to overturn that grant of licensing. The same thing, though, also applies for licenses coming from other countries, because it's unlikely that another country is going to license its private entities, again, to directly interfere with you. But if there is the possibility for interference, then there needs to be the consultations, or at least the consultations offers an avenue by which that dispute can be resolved. And those disputes will be resolved here. They're not going to be resolved in space. And this is a very important point. But with that important point, I think I'll leave it here. And thank you very much for your attention.
Thank you, Leslie, for those great comments, and we'll certainly look forward in the question and answer period to ask a few questions relating to that. Next, we have Wayne White to give us his thoughts, and I think he has a PowerPoint presentation as well.
Hi, thank you for having me here today. I hope I will have time to explain to you the many parallels that I've seen during this conference to what I've learned about space law over the years and my position on the issues. Today I'm going to talk about both real property rights and the right to own extracted resources in outer space. And I'm going to try a new approach today. I'm going to tell it as a narrative, placing different developments in space law within a historical context. Because I'm not sure I can finish it in 20 minutes, I'm going to start first with my conclusions and tell you what my views are on those two issues, and then I'll try and tell the whole story. So, I think the three of us are pretty much in agreement in our interpretation of the Outer Space Treaty. I'm very much in agreement that Article 2 of the Outer Space Treaty prohibits territorial sovereignty. And I did a great deal of reading from 1981 to 1983 of all the negotiating history of the Outer Space Treaty. Although it sounds like Professor Pocar has some knowledge that I have never come across, because some knowledge is personal knowledge that gets passed on. But in any event, Arthur Goldberg, who was the head negotiator for the U.S. Delegation that negotiated the Outer Space Treaty, I read a New York Times article, and he's the only one I've ever found in print who said Article 2 prohibits territorial sovereignty. It sounds simple, but why couldn't somebody just say that? But I also agree that the language of Article 2 prohibits nations from indirectly exercising jurisdiction over territory in any other means. And so there's a dichotomy between civil law countries and common law countries. In common law countries, it developed from a feudal system in which the crown owned all the lands, and then they would grant property rights to their subjects. In civil law countries, we have the mixing your labor with the soil, and under that theory, individuals create property rights, and the nations then recognize those property rights. Well, my analysis would be that the Outer Space Treaty theoretically could allow an individual to create property under the treaty, but no nation that's a party to the treaty could ever recognize those rights, or they would violate Article 2. So I think the practical reality is that Article 2 prohibits real property rights in outer space. So I started out writing my first article, Real Property Rights in Outer Space, with the objective of finding a way that we could bring the institution of property rights to outer space without withdrawing from the Outer Space Treaty. And in my view, those are the only two options. You either have to withdraw from the Outer Space Treaty and go for territorial claims, or you have to find a way to have a limited form of property rights that doesn't involve permanent jurisdiction over territory. And so that's what I have proposed over all these years, is that we do have a limited form of property rights that doesn't involve territorial sovereignty. So how would that work? If you look at the Outer Space Treaty and you analyze all the different clauses, you find that there is a bundle of rights that includes pretty much all of the jurisdictional authority that nations exercise within their territory, except for jurisdiction over territory. Article 8 says that states party to the treaty will exercise jurisdiction and control over their space objects and personnel while they're in outer space. The treaty says that nations continue to own their space objects and personal property when it's in outer space. Because they exercise jurisdiction over their people while they're in outer space, their citizens while they're in outer space, and because the treaty incorporates international law and the UN Charter by reference, nations have the right to defend and protect the safety of their citizens. And so that's another aspect of jurisdiction that they can exercise under the treaty. One concept that you see in international law is the concept of a safety zone. In the Continental Shelf Convention, there's a provision for safety zones around oil rigs on the continental shelf. The operator of an oil rig has the right within a certain distance to direct the navigation of ships in the vicinity to protect the safety of the facility and the people that work there. The space station has a control zone of 30 miles that goes around the space station, and within that area they control the navigation of space vehicles to ensure that they can dock safely with the station without damaging the facility or its occupants. So in my article, which I wrote in the 1980s, I proposed that we have a limited form of property rights whereby when and I was very focused from the beginning on private enterprise in outer space. And so what I said was, if an entity, including a private entity, puts a space object, for example, on the moon, that we could formally draft legislation which would say they have a right to exercise authority, delegated authority over a safety zone, clearly stating the U.S. has jurisdiction over these people while they're there, and including a safety zone around areas of ongoing activity, such as mining activity. And so this proposal has been out there all these years, and there have been some recent developments that are very interesting, driven by two companies that want to do mining in outer space. That brings up the second issue, which is can can entities, private companies, other organizations own extracted resources in outer space? And Professor Pocar brought our attention to Article 1 of the Outer Space Treaty, which says that space is free for exploration and use. Some of the early analogies that international law professors drew to this article was the freedom of the seas and the freedom to fish in international waters and to own the fish that you extracted from the oceans. And so I have a quote that if we have time I can show you in one of my articles of Professor, and I can never pronounce his name, Godquist? In any event, I don't know how to pronounce his name, but he has a nice succinct quote where he basically says, yes, you can use the resources of outer space, and you can own those resources. The Moon Treaty has an interesting take on that. It says that scientific missions can use enough resources to support their own mission, but then they have this organization that licenses any commercial activity where you would mine for the purposes of selling the extracted resources. And as both of our other speakers told us, none of the spacefaring nations have agreed to the Moon Treaty. Now, India, I'm not so sure about. I think they may have signed the treaty, but I'm not sure that they technically have, is it acceded or acceded? Acceded to the treaty. So I'm not sure if they're a party, but I don't think it really makes much difference, at least not as far as my proposal is concerned, because I think that what I'm proposing is something similar to the Deep Sea Mining Act, which the US enacted in the 1980s. What happened was the Moon Treaty and the Outer Space Treaty were negotiated during the same time period. Not by the same people, but during the same time period. But I believe that the circumstances that drove those treaties to be negotiated differed very substantially, and as a result, there was a different outcome with those treaties. The Law of the Sea, prior to the Law of the Sea Treaty, was a very disparate group of treaties that said a bunch of different things, and not everybody was party to the same treaty. And the Law of the Sea Treaty just did this wonderful job of bringing everything all together in a treaty where everyone could agree upon it. The United States, however, was unhappy with the resource appropriation provisions in both the Moon Treaty and the Law of the Sea Treaty. I think the fact that the Law of the Sea Treaty simplified the law and put it all in one place was so compelling. I think that's the reason why it has gained such acceptance. There's so many countries that are party to the treaty. We are not. The Navy has pushed long and hard for us to sign the treaty, but there's this reluctance to give up some of our sovereignty to this international organization that would license our activities. The Moon Treaty, on the other hand, was a push into a new area. It wasn't like we were pulling together a bunch of treaties. We were pushing out new ideas, which said that space is the common heritage of mankind. And that's one of the base problems of space law, of the international treaty law, is that the Committee on the Peaceful Uses of Outer Space operates on the basis of consensus. And so every single word in every treaty, all of the nations on the committee have to agree to every word. Well, you have civil law countries that have a whole different perspective on how you look at the law as compared to common law countries. So it's very difficult to get consensus. As a result, there are almost no definitions in any of the 5 outer space treaties, including, believe it or not, there's no definition of outer space. There is legally no agreement on where outer space begins. As a practical matter, nations have accepted 100 kilometers. So the problem with the Moon Treaty is that the United States and some of the other Western nations interpreted that phrase common heritage completely differently from other nations. And so we did not sign it. And we've been in kind of a limbo since then where we don't have positive law. We need positive law that says specifically, these are the rules. And so I believe that we're at another historical inflection point because there is now a very clear need for positive law that says, these are the rules, people. This is how it's going to work. And the reason for that is the development of the commercial space sector. The other thing, I think, is that, and Les talked about India, you know, now being a launching state. I think that the political environment is now at a point where we can put forth positive laws, because in the 70s, everyone viewed the resources of outer space as being similar to what we have on Earth. One pie that you had to cut into tinier and tinier, little tiny slices, a limited amount of resources with only so much to go around. And so the view was, well, the United States and the USSR are going to get out to space and they're going to monopolize all the resources and nobody else will get any. So, you know, we need to control it with the Moon Treaty and an organization which will license mining activities. But the fact of the matter is that there's an enormous amount of resources in outer space. And you couldn't possibly exhaust all the resources of the Moon before you have the capability of getting to Mars or the asteroid belt. And you can mine asteroids without destroying any scenic vistas or contaminating any waterways or any atmosphere. You know, the approach to outer space has to be completely different. We need those resources. In the long run, we need those resources to keep our planet clean. It's a good thing for us to go out there and learn how to do these things. And so, Professor Pocar mentioned a bill that was introduced in Congress last summer, and that's the Asteroids Bill. And actually, what that bill would do is it tells the mining companies that they have the right to own extracted resources. It's not actually real property rights. It's ownership of extracted resources. It was introduced by a congressman from the state of Washington, where one of the US space mining companies is located, and a Democrat. And then the other congressman was a Republican from Florida. And I would expect that the group of companies that would be the single most likely to benefit from a property rights law would be the launch companies, actually, not the space mining companies, but the launch companies. And so Florida has a very depressed economy since the shuttle program ended. And so they're very motivated to have commercial space activity because it can bring money to the Kennedy Space Center. So that bill was tabled, and in sometime last fall, Bigelow Aerospace is a company that builds inflatable space habitats.
I feel so guilty.
Okay. Anyway, they submitted a payload licensing request to the Office of Commercial Space Transportation, which licenses space launches and space ports. And in a very interesting development, Bigelow announced they released it to the media in February, that the FAA had responded to their request. They had filed this request saying, we intend to put a habitat on the Moon, and we want to know that our activities will be protected from interference. And the FAA came back, and in February, early February, they spoke publicly and said that the FAA was prepared to issue a license to Bigelow Aerospace if they should put a habitat on the Moon, which would protect them from interference from other parties. Essentially a safety zone concept. And so they said the reason we're doing this is to provide legal certainty so that the company will know that their investment will be protected. And that's the approach that I have always taken, is that you need to provide legal certainty so that people will invest in space, and so that people who take those risks know that their efforts will be protected. And so it's a very interesting development. It's consistent with what I've always proposed. It's legal under the Outer Space Treaty, and it doesn't require a congressional vote. So while I believe very strongly that you can own extracted resources, I would love to see the Asteroids Bill passed, because it would provide that certainty so that companies know for sure what the law says. But going back to this historical inflection point, my belief is that SpaceX has, if you look at their launch manifest, they're not just launching US satellites. They're launching satellites from a broad range of countries. India is now able to launch satellites for a broad range of countries. ESA is able to launch satellites for a broad range of countries. I think the mindset has changed. I think that enough countries believe that it's possible for them to put something on the moon that they're now receptive to these kind of laws. Because I think that mindset is finally changing, that they don't see it as something they're going to be excluded from. I think people are now realizing that a lot of countries can have commercial space activities or scientific space activities, and allowing these activities to be licensed is not going to keep them from doing what they want to do.
Thank you very much. I know we're short on time, but let me just give a few thoughts on with respect to what my thoughts are in international law. I think if you look at history for the past 50 years, our focus has been in low Earth orbit. And you look at what we've been doing in low Earth orbit, and you look at the international laws or the way we govern ourselves within low Earth orbit, and it's actually pretty mature. You've got the ITU, the International Telecommunications Union, that governs what you put up in space with respect to satellites. You have to go in and apply, and this is in Geneva, where you have to go in and apply, and for the radio spectrum, you got to apply for the satellite position, and all that has to be approved before you're even allowed to consider launching a satellite into space. And we have many satellites up in space, hundreds, if not thousands. And so that, over the course of 50 years, has sort of determined and has been sort of the working framework for how we operate in low Earth orbit. Now we're getting ready to jump beyond low Earth orbit, go back to the moon, and perhaps to Mars and beyond. And so we're at the infancy stage of this whole process. And I'm glad that we're talking about international law within space beyond low Earth orbit, because I think this is going to gel. It's not going to be an overnight thing where we are able to come up with a solution overnight, but as the parties and as the investors come in, the playmakers or the rainmakers within this whole process, that's what's going to be the influence in forming the framework. Yes, we have the space law that was developed in 1967, and the moon law that was in 1979, but all those are going to change in a way that we're going to change it such that it adheres to the needs of the entities at that time. And I think, having said that, are there any questions that you would like to ask to the panelists? Yes, sir.
Like with most technology, once somebody gets the technology, then there's like a race. Everybody copies it or emulates it or whatever. So right now there's not a lot of activity. I mean, relative to what it will be in the future. So how do you envision when somebody does get technology that makes it really feasible to go on a regular basis? How do you envision all these treaties coming into play when everybody's just rushing up to, it's like go west, young man type thing.
It's like the gold rush, right?
Go up.
May I answer that?
Sure, absolutely.
I don't know if it was directed at me, but that gives me a wonderful opportunity to talk about something I didn't have a chance to talk about.
You owe me $5.
first of all, my property proposal is a use it or lose it proposition because it's not tied to territory. So if you remove the space object and there are no longer any people activities going on, there's no more jurisdiction for the United States or whoever's citizens those are, and the property rights I'm proposing would cease to exist.
No homesteading, in other words.
Well, I'm proposing that's the way you would establish the property rights initially, but you would it would encourage people to they would either have to use that property or they'd have to sell it, or it would go away. And so I think it's even more of an incentive than terrestrial property rights for people to actually put the property to economic use, to make good use of it. My concerns, I didn't have a chance to show you the quote, but the attorney for Bigelow Aerospace at the press conference said that FAA had assured them that they were going to protect their facility from interference and areas of human activity located far away from the facility. That means that they're apparently intending to do a safety zone type protection for human mining activities, not necessarily in the vicinity of their facility. My concern is, A, are they going to have good regulations that say when that human activity ends, the property right ends? You know, in other words, looking at the temporal aspect of it, is it going to be, you know, you can't just give people property rights and then not pay any attention under this kind of an approach. My other concern is, well, how big is this safety zone? The Lunar X Prize is an ongoing contest for a company to land a small robot lander on the moon and take video, and there are certain requirements in order to win a prize of so many $1 million. NASA issued guidelines for these companies that are competing in this competition, and they said, basically they said you can't come within 200 miles of any of our historical landing sites because in 1/6 gravity, if you land a rocket in moon dust, the gravel goes like 200 miles because of the low gravity. And so, you know, NASA, does that mean that you think you should have a 200-mile safety zone around historical facilities? And that, to me, raises a tension between property owners will have a certain obligation to everyone else. And so I think ultimately NASA needs to put a glass dome over the Apollo 11 landing site or something. They need to take steps to protect that site. The other thing that needs to happen is that spaceports on the moon need to be in craters or someplace where you have some protection so that that dust and gravel doesn't go as far. So I think everybody needs to take some steps. You know, there will be, just like on Earth, property owners will have some obligations to others.
Another question? Yes, sir.
Two questions. One, are you all in agreement that use as defined in the Outer Space Treaty includes removal of minerals, part one? And second, are you convinced that U.S. companies have enough incentive to engage in that business under the current regulatory regime?
So that's Judge Fausto first.
Well, I still see some problem. The principle of non-appropriation. I mean, you can't just resolve the problem saying what I extract becomes my property. I'm not appropriating it. It's a bit. I mean, it's contradictory. There is some contradiction. It can be maintained, but I would prefer to go through the use. The use made to a limited effect, to a certain extent, allow extracting. But you remain with the principle of non-appropriation. And the principle of appropriation is difficult to overcome, in my view. In my view, it's difficult to go beyond that principle. And that's why I agree with you, John, at the end. The scenario you see, if I got it correctly, is that we might either have a new treaty that would overcome the difficulty. I could imagine that instead of a treaty could be an agreed declaration, interpretative declaration, something soft law that does not change the treaty as such, but where states have an agreement of principle. It could be a declaration of principle at this point, interpreting the treaty simply, and might be easier to achieve than a treaty. Or is the scenario that you consider more likely is a race. A race that may establish a practice, and de facto the practice will repeal the treaty, repeal the rule of appropriation. All the other provisions may remain. But I tend to agree with you on the practice, because unless the idea that I didn't see anywhere really of a soft law that could be passed in the caucus, for instance, passes an idea that came to me, having worked there, that sometimes you achieve a result with soft law. Unless that idea passes, probably the time of reaching a change of the treaty with more than 100 states will be so long that the company cannot wait and will start doing it, and states will allow them to do, like with this bill here, which speaks clearly of property rights. It's the bill does not say that this is not property. It's not well written, but it clearly says any resources obtained in outer space from an asteroid are the property of the entity that obtains such resources, which shall be entitled to all property rights thereto, consistent with the applicable provision of federal law. So it's property. It's clearly property.
I think it's personal property.
Personal property.
It says from the asteroid, not in the asteroid. And I think it could be worded better, but I'm sure that the intent was ownership of extracted resources.
And Leslie, did you want to comment on the second part of the question he indicated, which said, do you think the current regulations are enough of an incentive for private entities to get into this business?
Probably not. That's the short answer. I mean, if a company comes to me and is asking me to prepare an application for whatever, then under the current state of the law, there is an awful lot of gray areas, a lot of open areas. And I would tend to agree with what the judge said for the most part. One of the problems I have with the Asteroid Act is that it applies to every asteroid out there. If they wanted to say, identify a couple of particular near-Earth asteroids, near-Earth objects, for example, that would be one thing. But to say that everything in the asteroid belt is open for grabs, well, then you are going to have the incentive for the land grab, the rush. Whether that is practical or not is another question because of the difficulties, the expense, and the technology required. There's only so many players that are going to be involved in that race. And the licensing regime will act to put some limits and restraints on what private entities are going to be able to do. But if I can say, just to touch on something that Wayne said, if, for example, somebody wants to go and develop a mine on the lunar South Pole and take the ice, they're not going to get a 200-mile safety zone around that that's going to be enforceable, especially if that's the only ice deposit that's there on the moon. Because nobody's going to sit back and allow a private entity to, no other country is going to sit back and allow the United States to establish a monopoly by a private company on that one limited, very useful resource. So it all depends on context.
I should speak more to that point. The Associate Administrator for Commercial Space Transportation at the FAA, in his public statement, and the attorney for Bigelow Aerospace, they made very clear this is an expression of intent of what the FAA is going to do. The Associate Administrator said very clearly this is not property rights. And the other thing that they said, and I think it was the Bigelow attorney that said, the FAA has told us that there's a lot more that needs to be done. All they have done is assured us that they will prevent interference. They haven't said what the regulations are going to say or how they're going to be worded. And as in the case of previous FAA regulations for commercial space transportation, those regulations will be open for public comment before they become official. And so this is a move in the direction of encouraging commercial mining, but nothing is written in stone yet. This is a historic point, but it's just the start.
We have a question right here.
So what I've heard is that the sources of law that we have are outdated, and there's a need to update those laws by necessity, just because in the absence of regulation, things will happen anyway, whether by technology or by... So I've heard that very clearly. But just now, there was sort of a sense that the law itself, and we know that regulation either incentivizes or stalls. And I want to hear the normative argument as to why we ought to do this. We're certainly not doing a good job with our Earth planet, so why would we want to incentivize going into space? Really, I want to hear your thoughts, because my sense from you is that you think this would be a good thing, or maybe inevitable. And the inevitability part I get, and if we're going to be preemptive, I get. I worry that there's this sort of assumption that this is a good thing, and I just
Let me explain some technical information that I think you might find helpful. As you probably all know, there's a big debris problem. And one way to deal with debris is to refuel satellites so that they can last longer. They need fuel to station keep, to maintain their orbits, and that keeps them from crashing into other things. You can take water, ice from the moon, and you can break it up into oxygen and hydrogen and use it as rocket fuel. And so we can move to a regime where satellites are standardized to use that kind of fuel, and commercial companies can start refueling satellites. And Boeing has talked about putting fuel depots in low Earth orbit so that they could either refuel satellites. The other thing they could use that fuel for would be to go out and grab satellites that are dead, that don't have any more fuel, and they could boost them down into a disposal orbit so that they burn up in the atmosphere. So that's a big market, a potential market, and it's something that we really need, because what's the name of the effect where space debris is rapidly approaching the point where it has a cascade effect, where so many objects start hitting other objects that you end up with this huge debris field, which would make it really difficult to have any satellites, and we can't get to that point. And so there's a real need for fuel. If we can get it from outer space, once you have the infrastructure in space, it's a lot cheaper than boosting it from the Earth.
If I could address, get out of low Earth orbit and go back to the moon and the celestial bodies for a moment. One of the things in my slides that I didn't get to talk about are the environmental protection provisions of the space treaties, both in the Outer Space Treaty and in the Moon Agreement. And those would have to be respected by any company that's going up there. This would be part of the licensing requirements. They would have to establish to the satisfaction of the government that what they are going to be doing, what they are proposing to do, is not going to violate these environmental protection provisions. Now, they are very broad in general, those environmental protection provisions, but basically they prohibit entities, states, private entities, from disrupting the natural environment or causing harmful interference with the natural environment, depending on which instrument you're looking at. There are also corresponding provisions that, very tangential here, that relate to the return of extraterrestrial material and altering the environment of the Earth. Regarding the rocket fuel and so on, you're going to talk about utilizing ice and distilling hydrogen and oxygen from a limited resource. That's one thing, but then there's also other proposals out there that may be able to use helium-3 as a source of rocket fuel. And that's a virtually unlimited resource because it covers the lunar surface. And so you don't have to have just the one localized mine at the South Pole with a monopoly there. you could have any number of entities mining helium-3 from the surface. I'm not sure, though, that technically and economically it would make sense to get the fuel from the moon and bring it back into low Earth orbit or even medium Earth orbit, but those are other issues besides legal issues.
The problem, I agree with you, but of this legal framework, the problem is then how do you enforce it? Supposing, because the company would be under the control of the state. The state is responsible vis-à-vis as a state. There is no doubt under the treaty. But the responsibility of the company, if it is against another company that may, how do you resolve the problem? I mean, if you can resolve it between the states, because each has a company that has committed a violation. If you have the same states, will be the states because it has jurisdiction over the object sent out. But there are two of other states. Are you resolving it in which forum? State A or B? You will have a problem of jurisdiction difficult to resolve.
What, the Deep Sea Mining Act was not, we didn't do that by ourselves. The Deep Sea Mining Act said we will protect deep sea miners, U.S. deep sea mining companies from interference by other countries. But it was done in concert with 4 or 5 other nations. And all of the other nations enacted similar laws, and all of the laws had reciprocity provisions. So Russia, Germany, France, and Japan, and I think one other country, all passed laws similar to ours, and every one of them said, we will recognize the claims of other countries that pass similar laws. And so that's what I had proposed for my property law, was that the U.S. go and talk to its allies and say, we want to do this, and we'd like you to do it with us. And so then, if you can get all the spacefaring nations to do that and have reciprocity clauses, it's a way of accomplishing something without having to get worldwide agreement on a treaty.
If I can, a couple of very quick points. Regarding the law of the Sea Convention, it also contains a provision that the resources of the high seas are the common heritage of mankind. So it has the same terminology that the Moon Agreement does, and I just wanted to make sure that that's clear.
One last question, guys. You guys have one more. Yes, sir, in the back.
Since you brought up the FAA and Bigelow Aerospace, I wanted to ask whether domestic legislation is necessarily the best way, since the State Department has taken a sort of contrary stance on the licensing agreement, that the licensing talks between the FAA and Bigelow Aerospace.
Well, that's not correct. I'm sorry. Actually, the FAA's action was preceded, and it says in their letter that they consulted with the DoD and NASA and the State Department before they sent the letter to Bigelow Aerospace and before it became public. And in fact, the Commercial Space Transportation Advisory Committee, which advises the Office of Commercial Space Transportation, had a hearing in December, and the State Department representative stood up and said, our allies are not asking whether we're going to do this, they're asking how we're going to do this. He was very much in favor of doing it. And in fact, I'd love, if you wanted to stay after, I can probably find it. They webcast it and the video is available. You can hear what he has to say. It's very interesting.
I want to thank all three panelists for being here. I think the one parting thought, I just want to give my own 2 cents worth on this, is the fact that I repeat my thoughts in the sense that these type of laws are going to develop, by the time we get to the point where it's economically feasible to get to the moon and bring resources back or any other asteroid, it's going to be a good 50 years before we do that. I tell you what concerns me the most these days is the access of space to countries like India that pretty soon will be, it is China, but other countries that will then utilize it for the weaponization of space in terms of putting kinetic energy type of satellite killers to destroy the infrastructure of a particular country. I mean, there's those type of laws that we want to make sure that we're able to enforce and be able, because I think that's a more immediate need than than the commercialization of space. That's my 2 cents worth, but I'd like to thank Judge Fausto Pocar, Leslie Tennen, and Wayne White for serving as panelists. I think it was a very, very informative panel session, and thank you very much.